Is there anyone here for the EFF today?
I didn't actually check. I thought they were here, but I didn't.
I'm told that the candidate attorney, so I don't think she has rights of appearance, for the corresponding attorney for the EFF is court present, the lady with the red jacket.
Well, I suppose the EFF was alerted yesterday when I asked Mr. Nukaitobi what his attitude was with regard to the position of the EFF. They were alerted that they were alerted that he might raise the issue of their liability for costs today.
Yes, indeed. That was clear from what we addressed yesterday. So let me deal then with the appraisal of the evidence, because it's absolutely essential to get the right facts. Now, we do this in order to answer two claims. The first is the claim that when the Speaker made her decision, she wasn't fully appreciative of the prevailing political climate. And the second claim being that the ANC subjected its MPs to undue political threats. So those are the two claims that sort of remain hanging that need to be clarified. Now, we are aware that the case that was argued yesterday is limited to, I would say, the unconstitutionality of the discretion of the Speaker, as opposed to the unconstitutionality of the vote by the MPs. But the problem still remains that there is a residual concern that even the vote was an unconstitutional vote, and that is why it needs to be addressed. So where the case is pleaded initially of the ATM, you find it at page 32, at paragraph 72 and 73. That's the case for the unconstitutionality of the vote. Those are the two paragraphs. I see Mr. Gasbot has just arrived. So
just repeat that page numbers again.
It's page 32, paragraph 72 and 73. So that's the case of the Speaker. Sorry, that's the case of the ATM in relation to the unconstitutionality of the vote. What they say there is they accept that the National Assembly acted lawfully. But what they say is that the unlawfulness was because they were straitjacketed into an unlawful procedure through the vote. So that's the only basis for the unlawfulness. So this is not one of those cases where you can impugn the vote on the grounds that people were bribed, or you can impugn the vote on the grounds that people were unduly influenced and there was undue political pressure. The case is a purely procedural one, and what is being argued is that it had the outcome or the consequence of rendering the vote itself as being unconstitutional or unlawful. So this is the full extent of the case made in support, I think, of prayer 4. To the notice
3, I think it was.
Prayer 3, yes. Prayer 3 to the notice of motion, which is the unconstitutionality of the vote. So what are the facts then that are pleaded by the ANC to explain precisely how this came about? So this you will find from page 162 to 176. So these are the facts pleaded by the ANC in explaining how the vote came the way it was. Now, I don't have the time to read everything there, but I want to highlight 7 key facets of the factual account. One is the panel report was published on the 30th of November, 2022. That you will find in paragraph 23. Number 2, on the 1st of December, the ATM proposed a secret ballot. So a day later, 2 days later, they proposed a secret ballot. That you will find in paragraph 27. On the 2nd of December, the Forum of Opposition Parties, of which the ATM is a key participant, then made a call that its members must vote in support of progressing the report to the establishment of the impeachment committee. That you will find at paragraph 28. And here is the crucial fact then. On the 4th of December, the Speaker made a decision. 4th of December. She makes the decision that this will be an open voting procedure. And then on the 5th of December, the National Assembly Programming Committee meets. And on that same day, the 5th of December, the ANC-NEC meets. And the reason why that is crucial is that the ANC-NEC meets after the Speaker has made a decision. At the time she makes the decision, she does not know what the NEC is going to decide, which completely shows that this idea that the NEC has put undue pressure on the Speaker is unfounded. The Speaker acted independently. And then it's after the 5th where the ATM essentially attempts to get the Speaker to reconsider her decision. And she tells them that she's not going to reconsider her decision. And then the 7th fact is, on the 13th of December is then the vote. Now, if I can ask the court to have regard then to paragraph 40, which is at page 169, which is the meeting of the programming committee of the 5th of December. What happened there? Paragraph 40 says, on 5 December 2022, another special meeting of the National Assembly Programming Committee. So there was first one on the 1st of December, and the second one on the 5th was convened. It was agreed that a sitting would be scheduled for 13 December 2022 for the consideration of the Section 89 Independent Panel Report. At the meeting, Ms. Siviwe Gwarube, or Gwahobe, the chief whip of the opposition, which is the DA, confirmed that the DA had made a request in March 2022 for a manual voting procedure to be adopted, and again reiterated the DA's request for the adoption of a manual roll call voting procedure.
What does all that mean? I'm not that familiar with those.
It is explained in the next sentence. Yes, it says, what a manual voting procedure would entail is that each member of parliament would be required to place on record their individual votes rather than voting through the chief whips. The reason advanced by the chief whip of the opposition was that for purposes of advancing accountability and transparency, it would be important for members of parliament to pronounce their vote publicly.
So it's an open vote?
That's an open vote. For record purposes, so that the public would know how they voted, fully explained. Then, listen to what happens thereafter. This proposal was supported by the other political parties, namely the ANC, the DA, the EFF, the African Christian Democratic Party, the UDM, the IFP, the Freedom Front Plus, the AIC, as well as the applicant.
That was on the 5th of December.
On the 5th of December, everybody says it must be a manual voting procedure, it must be announced, each individual must explain. And then that is the footnote where the full video of that exchange is footnote 2. Now, I went last night to the replying affidavit to see how the applicant deals with this allegation. It's ignored. Ignored completely. The EFF doesn't touch it at all. So, what you have on these facts, and this is something glossed over, in fact, just never attended to. It's the most remarkable thing. Is you have the speaker deciding on the 4th and communicating the decision. The applicant is still quibbling about it, no doubt, because they write subsequent letters after saying we want closed. But what you cannot get away from is that on the 5th, it's not the speaker, it's the DA at the forum, at the NACP, the DA that says we want open, everyone must see, and everyone supports it. So it's understandable when the speaker says to them, because the EFF writes 2 letters, the ATM also writes 2 other letters between the 5th and the 13th. And then even on the 13th, they stand up and they say we want a secret voting system. But it's perfectly understandable for the speaker to say, I made my decision on the 4th. You yourselves confirmed that you supported what the DA said and the reasons that the DA said. And therefore, I am not changing. And the DA explains at paragraph 40 that the reason we want it is so that the public must know how we voted. In other words, we as MPs are being accountable. Accountability is not a one-way street. So what this shows is that it is utterly false on these facts that it is the ANC that was driving an open voting system. It was also the DA and everybody else. Now, it is true that the ATM and the EFF revised their positions, and they subsequently asked for a secret voting system, and they claimed that the facts had changed because of what Mr. Paul Mashatile had said. So, what then? So that is what are the true facts leading to the 13th. So we see at paragraph 41, where Mr. Zungula says that the Speaker had rejected his party's request for a secret ballot and pleaded instead for the method proposed by the chief whip of the opposition. And that is where that footnote 2 comes in. And then it says, whilst at this meeting, the Speaker expressed the view that a secret ballot would only be considered under extraordinary circumstances. The Speaker's final decisions and the reason for that decision are contained in the letter dated 4 December 2022 discussed above. And this is all perfectly understandable. These are people trying to work out how do we deal with the vote on the 13th. Certain proposals are made. At a certain point in time, everyone says it must be open.
But Mr. Nkatoba, the extraordinary circumstances that the ATM alleges is the fact that what is being said by Mr. Mantashe and Mr. Paul Mashatile.
Yes, I want to deal with that now. So what then is the case that is being made for the secret ballot? I've shown the court what case is made by the ATM in relation to why the vote itself was tainted. The case that we then hear is precisely what your Lordship has pointed to me. We start at page 139, and let's examine those facts closely, because it's of no help. Actually, it starts at 138. It's really of no help to gloss over the evidence and to make general hypothetical statements. So the first document that is in issue, yes, it's in the EFF answering affidavit at page 138 and 139. So that's the first evidence of this extraordinary pressure that is being put on MPs. But what does the document say? So the document is dated the 11th of December 2022. So we know it's irrelevant to the decision of the Speaker because that decision was made on the 4th already. So this is now 2 weeks after the event. So it cannot be used to impugn the decision taken on the 4th, which is supported on the 5th. It's completely irrelevant. But even if you assess what it says, turn over the page to 139 and look at the third paragraph from the top. So it first explains what the ANC wanted, which is this must be people must vote to reject the report. And then it says the dissenting ANC MPs seemed unfazed by the possibility of being expelled. So even as the announcement was being made, the dissenting ANC MPs were unfazed. And then there is evidence of this being unfazed. It is Lawrence MacDonald who expressly says publicly, it is quite disturbing that the ANC is making this a political matter. This is a parliamentary matter. It is not a process of removing a president, but getting information. I know they are going to come for us. How can you be expelled for doing your work? So one MP explicitly expressly says, I'm going to vote against what the party says. The next one, Mervyn Dix, is also quoted where he says he is not going to obey an unethical instruction from the ANC. I am not voting with the opposition for an unpopular motion against the president, unlike what Hanekom, Mondli, Praveen, and others did. So even as the report is issued, it does not show any evidence of pressure being brought to bear. It actually shows some members of the ANC explicitly stating what their position is going to be. Why this is crucial is because if you remember the letter from the Speaker says I know that this is being debated, and I also know that there are members who have explicitly, publicly voiced their opposition to the ANC. She took that into account. She is absolutely right, because there is clear evidence, even on the report that has been published, that some ANC MPs are opposed to what their party wants them to do in relation to the Phala Phala report. That's the first source of this pressure. So what does that document show? It shows absolutely no pressure. It shows a debate, it shows dissenting views. The second document we have is page 140, which 140 to 144.
But on that score, having regard to have said, well, I've taken into account, you can't sort of consider what weights here. Being expelled, and therefore consider a close vote.
Yes, of course the Speaker must take that into account, but she did. That's the point I'm making. But she did take into account. What she also took into account was that those MPs who wanted to follow their own view explicitly stated that they would follow their own view, which is what she says she took into account. So she knows for a fact that an ANC MP who says, I'm going to do what I want, has said so. And they indeed, as we know, of course at the time she didn't know, but as we know, they actually did vote according to their own personal wishes. So
yes, but the argument is being made, there might have been more if it was sort of a secret ballot.
It is the most speculative, hypothetical case I've ever encountered.
Doesn't the Speaker, isn't the Speaker entitled to proceed on the assumption that members of Parliament will be true to their oaths?
Yes, and that is, I'm going to address that actually when I deal with the analysis of this supposed conflict between the oath and the party position. But what I'm dealing with right now is to show that this evidence of the threat is not borne out by the very same documents that have been produced. So you are asked, Justice Branch, to speculate, draw inferences, make hypothetical conclusions. It's actually ridiculous. Then the next document we hear is page 140 to 144. Okay, let's look at what that document says.
Just tell me what that document is. I'm not looking at the document.
It is an annexure. It's FS5. It is an annexure to the EFF answering affidavit. It's also evidence of this pressure being brought to bear. Now, the founding affidavit already says this is an irrelevant document because this is a document of 6 years ago. And if you look at FS5, do not vote with conscience against Zuma. Matashe warns ANC MPs. Newswire, 6 years ago. I mean, Justice Stefan, this is why this is a ridiculous case. Someone goes and they dredge up something from the internet of 6 years ago. You know that this was before the vote against President Zuma on the motion of no confidence, even before the matter went to the Constitutional Court. When the law in the UDM case says, if you are going to assess the prevailing political climate, it's situation specific. Then, so that's the second big evidence that we are meant to be dealing with. Then the third one is...
But one would assume that Mr. Mantashe's views hasn't changed on this score.
Yes, that is why you have to speculate to find for the applicant. Because, let me just make a different point on this. I once acted for MPs. You can, at the very least, get an MP to give you an affidavit in which they say, I don't want my name to be mentioned. You did on an anonymous basis. I've never seen a scenario like this where the best evidence we have is a hodgepodge of newspaper articles assembled together in a very random fashion from different periods of time. I just don't understand what's happening in this case. So then the last document
if you can't understand it, now imagine how difficult.
And then the last document is this one at page 147 to 149. Now, this is the announcement made by Mr. Paul Mashatile, expressing what the ANC's position is going to be. It's precisely in the same category as the 5th December statement by the Forum for the Opposition. Everyone is lobbying for a position. If you are now going to be asked as this Western Cape division to elevate lobbying into threats, you are going to be a laughing stock. So the three best pieces of evidence, I've just analyzed them to you now. They ultimately do not prove anything. And then on the side of the ATM, we know the two paragraphs, 72 and 73, about why the vote should be impugned. So we have absolutely no admissible evidence of any threats against anyone. What do the facts show that are pleaded by the ANC? Because the ANC is in the best position to tell the court why it voted the way it did and what procedure was followed. This is set out in full between page 180 to 184. And again, I don't have the time to take the court through each and every paragraph there, but I want to tell the court the following. The members of the ANC who are MPs, more than 50% of them sit in the NEC. They also sit in the National Working Committee. So it's physically the same individuals. They meet in the NEC. They decide in the NWC first before it went to the NEC. They decide our position is the following. And again, there's a lot of distortion in this case. The ANC's position is not that the president should never be held accountable forever in a day. Their position is that there are certain gaps that we have identified in this report. There are certain other procedures that are still being pursued, including the public protector, including the Hawks, etc. At a certain point in time, they will all be conclusive. Once the picture is clear and is more conclusive, we want to reconsider the position. And we may well take the view that a Section 89 impeachment committee is desirable. So this idea that the topic is closed because of that vote is unfounded. The topic is not closed. Who knows what the public protector will find? Who knows what the Hawks will find? So the view they take, which is fully pleaded in these passages I have referred to, is this. A lot of evidence is still outstanding. We don't know enough, and there's a lot of taking into account of hearsay evidence. So it's not safe at this stage to put this through. But they debate that fully at the NWC. Everyone who has a dissenting view expresses it. They debate it fully at the NEC. Everyone who has a dissenting view expresses it. They also debate it fully at the parliamentary caucus of the ANC. Everyone with a dissenting view expresses it. Then, on the fourth occasion, they even take legal advice. If you're going to be fair to the assessment of the evidence, the most carefully considered view was actually the ANC view. In all of this that we are dealing with, most carefully considered was the ANC view. Which is why it's not surprising that there are people still within the ANC who were not satisfied and they voted the way that they did. So those are the actual facts of how the decision was made. There is no basis to assume from those facts that what happened is that a certain number of people sat on planet Mars, then they issued an instruction to people that were on planet Earth. These were the same people. They were deliberating what is the best way of responding to something that they obviously thought was important for the country. And their view was, it's too early. We will deal with it at a later stage when new evidence emerges. And for now, we're not voting in support. So you have a hyperbole claim that is made by the applicants. You have a hodgepodge of media statements that have been randomly assembled together, and you are told to make something out of them. And you have a coherent defense put by the ANC, not dealt with in the replying affidavit. And this is an application for final relief. You must apply NDPP versus Zuma and Plascon Evans. That then takes me to the next big topic once I have dispensed with the facts, which is what is the law on discipline of the party versus the constitutional requirement that MPs must vote according to conscience. You have been presented a spectre of an argument that draws a distinction between these two requirements. We have put together the law on this topic in our heads of argument from page 11 right up to page 17 under the heading, the discipline fallacy. The starting point, of course, is Section 1 of the Constitution, Section 1D. So one of the founding values of the Constitution under D is universal adult suffrage, a national common voters' roll, regular elections, and a multi-party system of democratic government. And then you'll see this given effect too by Section 19 of the Constitution, which deals with political rights. And it says every citizen is free to make political choices, which includes the rights to form a political party, to participate in the activities of or recruit members of a political party, and C, to campaign for a political party or cause. So, in a multi-party system, you get through parliament via a political party. There is, of course, a recent judgment which says there is a new alternative way, which is you can stand as an independent. But in a multi-party system, the Constitutional Court has recognized in at least 4 judgments that the party is entitled to take action against its members when they go against the party line. In other words, it is utterly false as a matter of law to suppose that a member of a political party is immune from discipline for the conduct that they display at Parliament. This is why, Justice Lagrange, you get this hypocrisy in which the Forum for the Opposition, actually it was you, Justice Tulare, you get this hypocritical argument in which the Forum for the Opposition issues an instruction under the threat of discipline. That instruction is not light, it's under the threat of discipline. And then it complains that the ANC is issuing its own desires to its own members. The only consistent way of looking at the argument is that both of them actually acted lawfully, because a party that is recognized under the Constitution is entitled to express its wishes to its MPs. This is an old English tradition that comes from the 3-line whip system. It's not new, it's part and parcel of the parliamentary system of England, which we adopted in this country. A party can issue a 3-line whip, and once a 3-line whip is issued, MPs are required to obey the 3-line whip of the party. Otherwise, the Westminster system is unworkable. The Constitutional Court has repeatedly made this finding. One, it's paragraph 186 of the certification case, which we cite at paragraph 39 of our heads, page 13.
Sorry, did you say 180?
186
Yeah.
Of the certification judgment, we cite at paragraph 39 of our heads of argument. And the highlighted, it's a long paragraph, but the highlighted portion, so this is right at the foundation of our constitutional order. The highlighted portion says that if you have this party system, that's going to result in subversion of accountability and responsiveness of the legislature to the electorate. And the court says we do not agree. And then they say, under a list system of proportional representation, it is parties that the electorate vote for, and parties which must be accountable to the electorate. A party which abandons its manifesto in a way not accepted by the electorate will probably lose at the next election. And they were debating the anti-defection clause. So principle 1, if you have a party system, people vote for the party and MPs account to the party, and the party itself accounts to the electorate. And if it does not do its job, it's going to lose the next election. Number 2.
What do you say? Isn't there a certain tension between that? what was said in the passage in the certification judgment you just referred to, and what the then Chief Justice said in the UDM case about members of Parliament. Are you coming?
Yes, I'm coming to that
right,
because it's the last of the 4 judgments. Because even that UDM case.
Okay, if you're coming to it.
Thank you. Then number 2, we deal with this at paragraph 40.2 of our heads of argument. Again, in the certification judgment, where it says this anti-defection clause obliges members of a party who are elected by virtue of the inclusion of their names to the party list to remain loyal to that party. That means the expectations of voters who gave their support to the party. And then, at paragraph 41, and I want to read this out because the Constitutional Court is introducing party discipline into the structure of the Constitution. It says, in a democracy, the electoral system and the elections in accordance with that system provide the most important check on the legislature and its members. An anti-defection clause can act as an additional check on the legislators who become accountable, not only to the electorate and the legislature, but also to their party. It is the party that faces the voters during the succeeding election and has to justify its acts in the previous legislative period. Then it says, if members wish to be re-elected, they need to bear in mind party discipline. This does not amount to a reduction in accountability to the legislature. So that's third passage. And now, more directly, it's the New Nation movement, which is the decision that found that it was unconstitutional to confine the entitlement in Section 19 to political parties, and that an alternative route of independence must be, but it must be allowed. And then it stated, it is so that individual members of the legislature remain free to follow the dictates of personal conscience, but they do so at their own peril, because if they wish to be re-elected, they need to bear in mind party discipline. No one says you may not do what you want in Parliament. Vote according to your conscience. But also accept that in a multi-party system in which your name came through via a party, the party may legitimately take into account your conduct in Parliament in disobeying the 3-line whip. This is what happens in the Labour Party in the UK. And then we deal now with the UDM case, Justice Binsworth, which is paragraph 45. That again, it's a distortion to say that party discipline has been done away by the UDM case, because somehow party discipline is in conflict with personal conscience. Because the UDM says, which is the paragraph we cited, paragraph 45, and the UDM is paragraph 79, where it says, central to the freedom to follow the dictates of personal conscience is the oath of office. Members are required to swear or affirm faithfulness to the Republic and obedience to the Constitution. Nowhere does the Supreme Law provide for them to swear allegiance to their political parties, important players though they are in our constitutional scheme. Meaning, and that's why one must be very close, in the event of conflict between upholding constitutional values and party loyalty, their irrevocable undertaking to in effect serve the people and do only what is in their best interest must prevail. So the qualification is always where there is a conflict between your constitutional obligations and the loyalty to the party. When that conflict arises, is always a matter of fact. And in fact, there is a later passage in the UDM case, which is now the 5th paragraph, at paragraph 80. I think it was read yesterday by Justice Tulare, which we cited paragraph 49. And this now makes it abundantly clear what the obligations of an MP are. It says members are not supposed to always operate under the cover of secrecy. Considerations of transparency and openness sometimes demand a display of courage and the resoluteness to boldly advance the best interests of those they represent, no matter the consequences, including the risk of dismissal for non-compliance with the party's instructions. So the fact is this: as an MP, you are entitled to do whatever you want. But you must be courageous enough, because you've sworn allegiance to the Constitution. And you must be bold enough to tell us what you want to do, so that we can know whether in the next election to trust you enough to put you in that position because of your courage. You cannot always demand the cover of secrecy.
So in other words, what you're saying is it's in a situation where there's a conflict between the MP's duty to uphold the Constitution and the dictates of the party that he has to prefer upholding the Constitution.
Yes, but it is his choice. That is how conscience works. Conscience, my learned colleague, Ms. Sigalalo, put this to me yesterday, that what conscience requires of an MP is where they are put in that conflict, they must make an election.
And if they did that, the party probably would have great difficulty in sustaining an expulsion.
Precisely. You would have a perfect defense inside the party discipline. And in fact, I'm glad you raised that point, Justice Binswater, because in the passages I have referred to in the ANC answering affidavit, the ANC is at pains to explain that in instances, and I'll take two instances of true conscience, not, let's remove the president, etc., but true conscience. There is an election, there is a decision to be made about whether to allow same-sex marriages. You take the view that from a religious point of view, same-sex marriages are not permissible. Or there is a decision to be made about whether or not to allow abortion, which is a true scenario, whether to allow abortion. You take the view that from a religious perspective, you do not agree with abortion. How does the party deal with that? What you find in the answering affidavit of the ANC is that there is in fact an inbuilt system in which you can make presentations to the NEC and you can be excused from voting in conflict with your religious convictions, where there is something that's no longer controversial in this country, but it was once controversial whether to allow abortion or not, or whether to allow same-sex marriages. So the most developed system of dealing with these conflicts that do arise from time to time, internally in the ANC, has been established, which is people make representations to the NEC, and once the NEC, sometimes the NEC will excuse them from voting in conflict with what they believe. What we are dealing with here is pure politics. Let me just be frank about that. This is pure politics. Some people want the president gone, others do not want the president gone. The party has deliberated this fully. Some people have gone to the parliament and they've done what they wanted to do. But the removal of a president is not the same thing as deciding whether or not I'm going to vote in favor or against same-sex marriages or abortion, which is something that truly implicates conscience. We use the term conscience very loosely. The Constitution, Section 89, says you've got to prove 3 requirements before you can remove the president. So what's the role of conscience there? It's either the facts exist or they don't exist. It's an objective inquiry. And you cannot claim that the facts exist when they don't exist, no matter what your conscience tells you. We are really dealing with pure politics here. So we come back then to this idea of a conflict. When did this conflict arise? Because whether or not a conflict arises is a question of fact. Justice Raj, you have zero evidence that any conflict ever arose. The only evidence you have, which is what has come from the ANC, is that the MPs who voted to reject the report agreed with that vote. That is what they wanted to do. And this idea that if you agree with the report, that's not conscience. If you disagree with the report, that is conscience. That is just nonsense. Really, really just nonsense. Because you cannot tell the MPs that those MPs who vote yes do not want accountability. Those MPs who vote no want accountability. It just makes absolutely no legal sense whatsoever. So at the end of the day, we come back to where we started, which is you are being asked to speculate. You are not being provided with any evidence whatsoever, A, of party interference, or B, of any conflict arising between what the members wanted to do and what they did in the end. And the only evidence that is admissible on the rules of evidence that you must apply, plus on evidence which you can reject what you say only if it is far-fetched. You are left ultimately with the version of the ANC as the most coherent, conclusive, and admissible evidence. And where it ultimately leads you is, we debated, those who disagreed expressed their views, those who didn't like it still voted against, and those who supported it went along with the decision. So that is really the end of this case. What we find at the end, once we have gone through all of these superficialities, we find that there's no case at the bottom.
It seems, if I understand the case correctly, and I think I've asked Advocate Katz about it, and he indicated that it's the threat that suffices.
Yes.
And it seems to me that what the ATM wants this court to accept is that those members who voted in a way contrary to the party position of the ANC are an exception. That there is the general membership. It's not in that category of exception.
Yes. No, I mean that's why, Justice Tulare, I say that if you accepted that, this court would be a laughing stock, because the next question that will be asked is, what is the evidence for that? I mean, that's really the problem. What is the evidence for saying that? We have had many of these loose statements, no facts. I accept that in one scenario, if I produce evidence of general bribery, you know, the Chief Matanzima once bribed the whole cabinet of Transkei. I mean, not Matanzima. Matanzima was the head of the cabinet, but this fellow, the crooked fellow from Northwest. No, not Mangope, the businessman. The businessman, not Mangope. Anyway, Kazna, yes. Once bribed the whole of the cabinet of Transkei. So it's not impossible to bribe everyone.
This is from Out Bay.
Now,
So my neighbour in Out Bay, not from the north.
You're lucky you can't defame the dead.
I'm told that he's dead, but
No,
I have a perfect defense of privilege. I'm speaking in court.
I'm not so sure about that.
But don't speak ill of the dead.
Yeah, so yes, it's his ancestors, Justice Tulare, will come after me. But the serious point I'm making here is this. It is possible, in a different case, to produce evidence that 50 members of the ANC were bribed, or they were visited at night and they were told that their children would be harmed. But you've got to produce some evidence. You can't just come to court on a speculative case. You've got to produce something. So the problem here is that you have a case that has no factual foundation at all. And that's why it's just a speculative case, an impossible case to answer. And then when the ANC presents the actual story of what happened internally and why people voted the way they did, we don't actually get any answer to that at all. Nothing. So I agree that is the best rendition of their case, that the 5 is an exception. An exception to what? They voted according to what they wanted. But those who voted in favor, that's what they wanted to do as well. So, and what is most striking about this comparison between what the opposition did is that everyone who is a member of the Forum for Opposition voted exactly the same as the dictates of the Forum for Opposition, exactly. Remember, Good and Al-Jamaa were not party to it, and they abstained. But everyone else just voted exactly the way that the Forum for the Opposition dictated. It's only in the ANC where there was a dissent. So where is the case? I mean, so there is just no case.
As I indicated to Advocate Katz, I think, it seems to me that if there was any threat hanging over for discipline, it was across the board.
Yes.
Because of the constitution
yes.
of the parties.
Yes.
it seems at best the only complaint is that ANC national office bearers reminded
Yes.
their members of that. But that threat appears, from my understanding of the constitutions of the parties, is there.
Yes. But in the context of the ANC, just one point to be added. The same people had made the same decision at NWC, at NEC, at the ANC Parliamentary Caucus in Parliament. They'd taken legal advice. So it was them who wanted that decision. There's no one who sat at Lutulu House and came around with a stick. Instead, it's the same people, they made that decision. It was their decision, that's what they wanted to do. So it's impossible to say that, well, I must look at what jacket they were wearing. You know, it's the same people, that's the decision they made. Now, so that's the end of the debate in relation to the law on party loyalty, in relation to how does one reconcile this conflict that may arise, but it doesn't arise on these facts, and how, in fact, what happened, what the ANC did. So what that means is that insofar as there is a residual case of an unconstitutional threat to ANC MPs, it has not been established here. It can be established in a different case. That leaves me with two more points to address, which are very short points, and I want to do that now quickly. The first is this issue of whether the case is not moot. Now, I want to suggest that the case, at least in relation to attacking the vote, is a moot case. Why? The decision of the Speaker was already made on the 4th. Mr. Butler emphasized this point because there was still some confusion about which decision is being attacked, on the 13th or on the 4th, but Mr. Butler already explained that this is the decision of the 4th. And in fact, everything we have had here is about the decision of the 4th. So on the 4th, you know the decision. On the 5th, that decision is reaffirmed at the National Assembly Planning Committee by the DA and by everybody else. Thereafter, it's applications for reconsiderations. But everyone knows that there is going to be a vote on the 13th, and everybody knows that that vote is going to be an open vote on the 13th. But nobody bothers to bring an application either to set aside the decision of the Speaker or to interdict its enforcement. What they do is actually worse than not acting to stop. They do two things. First is they actively associate themselves with the decision. The ATM did so in a letter because it told the Speaker that it agrees with her decision of the 4th, and it agrees that that decision is not tainted by ulterior motives. The ATM also sat in the meeting of the NACP on the 5th of December, in which it expressly associated itself with the view taken by the DA. So they acquiesce fully with the decision. Not only do they acquiesce fully with the decision, they also participate. If one is in doubt about their acquiescence on the 5th, that doubt is completely removed on the 13th. Because on the 13th, yes, they protest here, but they vote. They speak and they say, no, this must be reconsidered. But they vote. What happens is they lose the vote. They lose the vote. No doubt if they had won the vote, they would not be here. But they lose the vote. That is how a democratic process works. Sometimes you win the vote, sometimes you lose the vote. But they lost the vote on the 13th. They had completely acquiesced. The case had become totally moot by the time they went to the meeting of the 13th and they participated and voted. The time to have challenged this is after the 4th. They had 2 weeks to do so. Mr. Katz says that when I acted for the Speaker in the case that he is now involved with Mr. Biden, I told him that he would be premature if he came to court without asking for reconsideration. Yes, that's true, I told him that. But in this case, he did ask for reconsideration, and it was rejected. So what case is remaining then of the ATM on mootness? The case is dead, it's moot. it's impossible to reconstruct it.
Is it your submission that in these sort of circumstances, bearing in mind challenges have to be brought in the right way, at the right place, and at the right time, that by not acting before the vote is taken, when there is ample opportunity to do so, you forego the opportunity to make the challenge at all?
Yes, they do. You forgo that opportunity. There is another reason in this case. For a motion of no confidence, it's not a problem because you can always bring this back again. And that's why case one is completely moot, because they can bring a different case now. For an impeachment, it might be slightly different because an impeachment depends on that procedure that Chief Justice Sandile followed. But the rules actually answer this, because the reason you can't wait for a vote is because of clause 129P, which is at page 44.
Is that 44 of the record?
Of the record, yes. And the clause is 129P. So what that shows is that the recommendation of the Section 89 panel is not binding on the Assembly. And it's the Assembly that makes a final decision whether it is binding or not. And the way they make a decision about whether it is binding is the vote on the 13th. Right now, as a matter of law, that report of the former Chief Justice is dead, because it could only be given life by the vote of the 13th. That vote has taken place. It cannot be impugned. That vote cannot be challenged on any substantive grounds. It cannot be challenged on rationality. It cannot be challenged on people being bribed on any ground. That vote stays. It is only being challenged on a narrow basis of the procedure followed by the Speaker. But the vote is a valid vote. So that is why
I suppose it was implicit, and perhaps you made this point earlier. Let's just be sure that you did. I suppose it's implicit in the recorded basis of the ANC's decision that report could be tabled again if it passes scrutiny in the review that the President's brought.
Yes, there are many opportunities.
But that would be in terms of a separate motion,
yeah,
a new motion.
There will be a new process. There will be a new inquiry. I mean, take for instance this possibility that the public protector, and it's a realistic example. I'm not saying this to win the case. Take the possibility that the public protector, which the ANC says we cannot do it before she finishes. Take the possibility that she finds that, and she's much better than, not better technically, but she's got more investigative capabilities than the Section 89 panel. She can subpoena, she can interview, she'll do so many things. She says, I've now done this, I've dug into it. I think the President has a case to answer. The next day, ATM puts a motion. Let's let the matter move forward. The ANC reconsiders its position because it says in its papers, it's not a final word on this. We want to hear what the evidence is going to be. Or take another example. The Hawks are seized with the matter right now. They also have much more sophisticated investigative capabilities. They come with the view that says, actually, we think that this man has a case to answer. Case comes back. It comes back with new evidence. So we are not dealing with a matter that's closed forever and a day, dealing with a matter that's capable of being revisited. So to answer your point, Justice Biswat, yes, it's similar to a motion of no confidence. It's not dead, it can come back. But this particular report, on this particular occasion, is dead. It's moot.
Well, if that's so, has the President's review application become moot?
Yes, arguably it has become moot, but I'm not speaking for the President. Someone else will speak for the President.
I might have misread the papers. I only read through them once. I thought one of the considerations the ANC's NEC gave consideration to was the outcome of that review application.
Yes, indeed.
Now, if that review application, for example, endorsed the validity of the report, would the report be dead, or could it not be tabled again?
No, you see, it's very difficult where the specific, unless the vote, I mean, the only way to get back to this is impugning the vote.
No. The vote is taken on the basis, well, we're voting against at this stage the adoption of the report,
Yes.
because there's a pending review.
Yes.
Unfortunately, when members of Parliament vote, they don't give their reasons. But I mean, we do know that that's one of the considerations the ANC took into account, the pending review.
Yes. But you know, Justice Binswater, let me do this. What might be helpful is to take the court precisely to the reasons that are pleaded. And you will see those at page 184. It's necessary to look at what they said, because there is a risk that we will also have an incomplete discussion. So the first one is the panel misunderstanding its mandate. The second one at page 32 is the panel conflating information and evidence. The third one at page 186 is the panel relying on hearsay and media reports. And then where this is concluded is at paragraph 89. Thus, the resolution of the ANC and its members against proceeding with the Section 89(1) inquiry and referring the matter to the impeachment committee was not a knee-jerk reaction arising out of the fact that the President is a member of the ANC. It was a carefully considered stance, deliberated and debated through the structures of the ANC. It involved a careful analysis of the Constitution, its requirements, as well as scrutinizing Section 89 independent panel report to ensure that it met the requirements set out in the Constitution. It did not, and for this reason, the ANC voted against proceeding with the Section 89 inquiry and referring the matter to the impeachment committee. And then that's the point I was making earlier. If at some stage in the future, actual evidence through a proper process emerges which justifies the setting of an impeachment inquiry, the ANC would be open to considering its position afresh. So when you actually look at the pleaded reasons, which are compatible with the submissions made by Mr. Lamola as an MP, what you find there is that it's an analysis of the report on its terms, which is then rejected.
Which is a consideration the court, if it's not persuaded the matter is moot, will have to undertake in the review.
Yes, I accept that entirely. I accept that. I think the only point I was answering is the role of the pending review, whether or not that played an appreciable impact.
No, I just raised the point with you in the context of you saying this report is dead. It seems to me that if all these grounds that exercise the ANC's mind that you've drawn our attention to in these passages are found by a court to be misdirected, well then the report might not be dead. The ANC might be in a position, informed by that judgment, to consider the report again, whether to accept it again or reject it again.
Yes, I mean, that is arguable, Justice Binswater. I don't want to take a firm view on that issue. The view I can express with confidence is that the only route to the reopening of that report is the setting aside of the vote. For as long as the vote remains a fact, its legal consequences are that the report is dead.
Yes, as things stand.
Yes.
I agree.
So that's the only point I make about before your lordships, the report is dead. Now, what should your lordships do about the affidavit submitted by the EFF? The law on this, I'll say that I forgot to hand up our authorities, but that's also because I only want to refer to one case.
Well, you've given us Wallace AJ's judgment in...
Oh yes, no, that was important. In fact, I didn't refer to it in my oral address. It's attached to the chronology, but what I would like you to look at there is paragraph 90 of the calm judgment, because it simply tells you what is the legal standard.
Paragraph?
90.
90, okay.
Yes, of the calm judgment. What it tells you is what is the legal standard for the setting aside of a vote. But admittedly, that was a vote under section 18, section 19, and not a vote for purposes of impeachment. But it tells you under what circumstances a court would set aside a vote, because a vote is an intensely personal thing. For a court to set it aside is an extraordinary remedy. And the court there tells you when you can set aside a vote. The judgment I would like the court to have regard to is at page 119 of the bundle that we've just submitted, which is the Kruger versus ACL Geomatics, a judgment of the Labour Appeal Court by Justice Wegley. I think he's a member of this division, Justice Taletsi and Justice Davis, who's also a member of this division. The relevant passage is at page 20, paragraph 9, and 10 and 11. This is what it says. So this is typically what happens. An applicant brings a case, the respondents oppose the case, but one of the respondents supports the case. And this is the law on this topic. In my view, the Labour Court erred in allowing GSA's affidavit, because GSA supported a case brought by the applicant, GSA's affidavit to stand, and more importantly, allowing it to present argument as if it was an applicant in the relief sought by the said appellant. Paragraph 10, a respondent in a motion application cannot, in my view, simply decide to be another applicant. In this regard, the judgment of the Labour Court records the submissions made by counsel for the respondent. Paragraph 4 of what Mr. Pringle said, who appeared on behalf of ACL, submitted that having been cited as a respondent, GSA had three options. First, it was entitled to oppose the relief sought, in which event it was entitled to file an answering affidavit refuting the applicant's case. Secondly, it could have elected not to oppose the application, but to abide by the relief sought. Third, the GSA could have decided, if it was not content to let the applicants make out a case for the application, to be joined as a second applicant in order to make out its own case. In the latter instance, ACL would have filed an answering affidavit to deal with the case presented by GSA as an applicant, would not have filed. What GSA was not permitted to do in the present proceedings was to file an answering affidavit, the sole purpose of which was to build on the case for the relief sought by the applicants in their notice of motion, under the guise of a respondent which had elected not to join issue with ACL. On this basis, Mr. Pringle submitted that the applicants are not entitled to rely on this proceedings on the untested evidence presented by GSA, since it formed no part of the founding affidavit and therefore not part of their case. Further, he submitted that GSA's counsel is not entitled to claim an argument on behalf of GSA, the relief sought by the applicants in their notice of motion. In other words, GSA is not permitted to assume the role of a Trojan horse, acting in every way as if it is a co-applicant, without claiming any relief in its own name and thus seeking to avoid any liability for costs. Paragraph 11, in my view, the above submissions are indeed correct. I may add that in the affidavit filed by it, GSA not only sought to support the said appellant's case, but went on to ask for the relief as prayed for in the notice of motion. Once GSA sought the relief asked for by the said appellants, it was no longer placing evidence before the court of quo. It was making itself an applicant in the proceedings. In allowing the affidavit filed by GSA in the form that the court did, it was in effect allowing a further founding affidavit. The respondents in the Labour Court thus suddenly found itself defending itself not only against the applicants, but also against a co-respondent. What is it then to do? Answer the applicant's papers or answer the correspondence papers? This clearly goes against the fundamental principle in our law. But it is the founding affidavit filed in support of the notice of motion that makes the case which the respondent must meet, allowing the correspondent to file answering papers in which it seeks the relief sought by an applicant while not seeking to be an applicant in the proceedings cannot be and is not permissible, nor is it open to a court to allow such procedure on any grounds. The court does not have a discretion to do so, allowing the GSA affidavit not only prejudices the respondent, but placed the respondent in a position where it had to conduct a defense on two fronts, one against the applicants and the other against the correspondent. This is untenable because GSA and the applicant effectively formed a tag team against the respondent. This is a full answer to...
Yeah, but this case was slightly different. I thought the papers of the EFF were quite cleverly drawn. They resisted the temptation of asking for the relief. They just suggested that it might be a good idea. The words used like suggestion and things to that effect throughout the EFF.
I wanted to show you.
It struck me that the EFF cast itself without being admitted as such as a sort of amicus curiae. But I mean, I raised this with the EFF's counsel yesterday, and the attitude taken was, oh well, we were cited so we're entitled to be heard. I must say, being a procedural stickler, what the Labour Appeal Court said appeals to me more. But by abandoning your Rule 30 approach, aren't we dealing with a situation where, and I used this expression yesterday, it's been accepted in these proceedings that the EFF is a de facto co-applicant. The question arises then, well, in those circumstances, what is its exposure to costs?
Yes. You see, it's not, I mean, according to this judgment, which is why we thought it would be inappropriate to deal with this as a Rule 30. It's not a defective procedure. It's just that there is no discretion to allow them to play this double role, because the choice they have is, if you are opposing, you must oppose.
Well, what are we to do with their affidavit? Ignore it.
What the Labour Appeal Court did actually was exactly that. It just said it should just be disregarded. Just does not form part of the case. That's what the Labour Appeal Court said.
Well, there I have some difficulties. You know, I mean, if something's to be disregarded, it should ordinarily, you know, for example, objectionable matter in an affidavit is an application to strike it out.
Yes, in fact, what had happened is that the Labour Court had refused to strike it, and then the Labour Court, I'm wrong when I say it disregarded. The Labour Court found that it should have been struck. It's because of these considerations that you can't be cited as a respondent and then refuse to come as an applicant.
Yes, I mean, I have great difficulty as to how we are made to deal with this affidavit, and I raised that yesterday. Your submission, if I understand you, so we just ignore it.
Yes, the law on this point is that...
Is it terribly important in this case because there are no real factual issues?
You see, Justice Binns, what? It's ultimately irrelevant. That is why the Rule 30 issue, we've abandoned it. It's ultimately irrelevant. Take it into account, do whatever you want with it.
But I mean, sorry to interrupt you, it was indicated that we can regard the EFF as a co-applicant. So
that places the matter then differently. If they have taken the formal view that they are a co-applicant, but I don't want to be unfair to Mr. Kasibut. He can confirm if they are a co-applicant.
He did yesterday. He didn't confirm that they're co-applicant. He didn't do that. He left it to the court. But he conceded we could treat the EFF as a de facto co-applicant.
No. You can't be a de facto. You have to be, in law, a co-applicant. You can't be de facto. You have to be in law a co-applicant. If he is committing that they are a co-applicant, this is irrelevant at the end of the day. But what had happened, Justice Binns?
Yeah, but we must get it procedurally right. It's not irrelevant in the true sense of the word.
No, that's true. In other words, what I'm trying to say is it's not decisive to the case we
No, of course not.
But the procedure must be right.
Yes.
I mean, the EFF's affidavit, my impression of it, is that it doesn't raise any factual issues that are in dispute. I mean, they talk about the EFF's letter to the Speaker not being answered and all that. Those sort of factual allegations are not disputed as I see it.
No.
And so the rest of the affidavit, like much of the paper in this case, is argumentative.
Yes. Well, I mean, there are some facts about, what Matasha said 6 years ago.
Even that's not in dispute.
Yes. So if the court wants to know procedurally what to do with it, my only point is you've got guidance from the Labour people. I am not going to take the matter any further because from the position of the ANC, there is no harm in letting that affidavit stand. But you have a discretion to ignore it. But from our position, there is no harm in letting them argue. There is no harm in letting their affidavit stand. But you have to apply plus one evidence, and if you do so, the version that counts is the ANC's version.
So we've got to treat, for that plus one evidence purpose, we've got to treat the EFF, if we have regard to its affidavit, as a de facto or de jure, whichever way you like it, co-applicant.
De jure. We obviously would like our costs against all de jure applicants.
Or even de facto ones.
Even de facto applicants. Thank you, my lords. I have nothing. Well, I must just check with my juniors. Nothing useful to add. Thank you.
Thank you, Mr. President. Mr. Katz, are you ready to reply?
I am. I understand counsel for the EFF would like a word in before I reply. I'm not sure if he wants to motivate it. I would not like him to go after me. If he is going to have an opportunity to say anything, I would prefer that he goes before me. He
Mr. Katz,
I'm not motivating that he should or shouldn't, just for him to do.
why don't we ask what he wants to do?
Yeah. Can counsel just indicate what is it that the points you would like to make?
Thank you, Justices. Firstly, I must apologize for my slight lateness. And perhaps I missed part of what the address was by my friend, Mr. Ibrahim. But what is clear is that the ANC has taken a stance fully, in fact, as a main argument, respond to the EFF, despite initially them filing a Rule 30 and 30A, which they subsequently abandoned. And our understanding was we would not be engaged, at least by the ANC.
Sorry, I couldn't hear that.
We would not be engaged by the ANC, at least as far as AA is concerned. At least that's how I understood this interview yesterday. What has since happened this morning is that he's fully gone into the EFF in terms of law at least, and how our submissions were flawed, and how our submitted facts were not to be admitted for various reasons that he's given. So what I'm appealing for, I mean, of course, subject to his own submission response thereto, is an opportunity at least to respond to the factual disputes that have now been put in place. What must be understood is that the fulcrum of the ANC's argument, at least as far as the facts are concerned, is that they did not have an opportunity to respond to the EFF's answering affidavit because it styled ourselves as responding.
That point hasn't been persisted in.
But
Your affidavit has been, the EFF's affidavit has been treated by the ANC on the basis that it doesn't raise any relevant factual issues, or material factual issues, and that the rest is argument. And Mr. Mukatobi has said, well, having regard to that Labour appeal court judgment he referred us to, it's up to us to decide whether we're going to have any regard to the EFF's affidavit or not. But if we do, he doesn't have any particular objection because of its essentially argumentative nature, but he does want costs against the EFF. So really, what you have to deal with is the cost issue.
Well, I want you to address two issues. Maybe that I misunderstood Mr. Mbaikobi, because it seemed to have been a dispute about what to make of the hopscotch articles as they refers to. That to me, square one, raised a factual dispute. So if the court understands Mr. Nkiweke to be making a concession about the admissibility of that factual account, then of course they will take an issue.
Well, as far as I could read the argument, understand the argument, there's no issue about the articles. It's just the articles are outdated. One was 6 years ago, and the other one was after the vote of the court. It happened on the 11th of December.
Maybe then let me make this point, and I promise I'll sit down. All I'm simply saying in response to the 6-year time lapse between the initial statement by Mr. Mantashe and where we are now, is that Mr. Mantashe was not making a statement in relation to that particular issue. It was a principal position by the ANC, and it has not been, the ANC has not distanced itself from that general principle. So for all times, that's the position of the ANC, and that's the point we want to make. Don't want to take the point any further,
okay.
And it remains relevant. And insofar as the costs are concerned, I mean, of course, ours, and we insist on this, we are merely involved to simply suggest what is just and equitable, and that's the relevance of the EFF. And we do not seek any costs against any party, but in light of the stance that has been taken by the ANC, was our understanding that we're taking what we should effectively abide by it. But in light of the development in relation to the costs as they are, well, as you understand it now, certainly the EFF at the very least is one cost against the ANC to implement.
So, we don't cost against the
Let me just clarify this. If the EFF wants to be treated as an amicus, we seek no cost against them. If they want to be treated as a co-applicant, the rule must apply.
Okay.
You know, you referred us to the Labour Appeal Court.
Precisely.
Puristic approach. There should be an application in terms of Section 16 on that. We'll have to make it what we can.
Yes, it seems to me that we are left to issue the EFF with an identity.
No, they chose their own identity. The point is really simple. If they say we're an amicus, no one wants costs against them. No one wants costs against any amicus. But if they are in fact a party, then the rule must apply. That's the only point. And I've shown the court what the authorities are.
Mr. Kasiboto, I didn't hear you that well this morning. Did you just say that the EFF should be treated as an amicus?
No.
No, you didn't. I didn't think you'd said that.
So the point I'm making is, and perhaps that's where my inarticulation comes in, and perhaps that's why perhaps I misled Mr. Nkiweke. The point I was simply making is the EFF has been cited as a respondent. It remains a respondent. Nothing in our answering affidavit directs as a motion that these are the remedies we seek. All we are simply saying is, in light of what the ATM seeks, what would be just and equitable in circumstances is a consideration of these remedies, which this
No, we've got that part. I did hear all that.
That's the point of it.
No, it was just this reference to an amicus. I thought I missed
Well, I
something.
said
But
it
you
didn't come
didn't.
from my mouth. Yes. That's what it is.
I was just alarmed when I thought I understood you to be saying something akin to seeking costs against the ANC if the court decides otherwise.
Well, the point Justice Tulano we're making is, we're in the hands of the court. Let's just be frank about that. But our principal position is that we're responding unequivocal about it. We just so happen to be aligned to the argument of the ATM. We just so happen to suggest what the just and equitable remedy is. We are not opposing anyone, neither are we supporting anyone. In principle, we so happen to be aligned. Now, what we are suggesting is, if the court takes the position, which we have not suggested, that we're a core applicant, which then attaches the cost issue, then we're saying, if then you are treated as such by this court, and the ANC seeks costs against us who are core applicants, then we want costs. But to the extent the court is with us on what we are submitting, which is we are mere respondents that are merely suggesting a just equitable remedy, and there are no finding of costs against us,
Thank you. Mr. Katia.
I'd like to address the reply in a number of ways. The first aspect that I'd like to address is the questions that have been raised on mootness in respect of ATM 1. I'd like to make then some brief submissions concerning both cases and then turn to ATM 2. Now, before I turn to this question of mootness and the various aspects that relate to that, I do want to make the following broad submission as to how we understand the case, taking into account, and importantly, Justice Binswood's comment that he in particular, and we would submit, we as well, are sticklers for procedure. Was it procedure is the sticking point here? We would be entitled to, and this is going to be my submission, Prayer 2 in the motion of no confidence case, and Prayers 2 and 3 in the impeachment case, on the basis of our learned friends' arguments on all the facts and on all the law. So we start off our proposition by having listened very carefully and fascinatingly to our learned friends, and we submit that Prayer 2 in the first case and Prayers 2 and 3 in the second case fall to be granted. We would understand, were to be found by the court, that even though we succeed in 2 and 3, we don't get substitution on the basis of the argument. I do not make the concession, I do not have that instruction, but certainly from a submission perspective, I would understand were the court to come to the conclusion 2 and 3, but no substitution. So let me start off with ATM 1, and in particular, this question of mootness. When a court decides mootness in general, and I'm going to give a small bundle of authorities on this question. The first aspect is there needs to be a fact that renders the relief sought moot, such as in the Phala case or the President case, the children there had left the school and had now dropped. That was the fact. And in a whole series of cases, that principle continues to apply, subject to what I'm going to hand up. Now I hand up a small bundle, but as a starting proposition, what is the fact here that has been pleaded or argued by the other side on this evidence? There isn't one. There's no...
What about the vote?
No, I'm talking about ATM 1. I'll come to ATM 2. I'm only talking about ATM 1 on this question of mootness. So on ATM 1, there is no fact that has been pleaded, and we know of no fact that renders the question of Prayer 2 of the notice of motion in ATM 1 moot. So there are two possible facts that we can speculate about. The one is the question of the motion lapsing. Now you heard yesterday on his feed, Mr. Bundan mentioned that, and he suggested why didn't we file an affidavit to that extent? Well, one, we haven't.
Isn't it governed by aren't these time things governed by the parliamentary rules?
There may or may not be, but there's no evidence.
Which he placed before us?
No, he hasn't. There's nothing.
Haven't we got the parliamentary rules?
No, there's no parliamentary rule that we placed it before you in our supplementary money yesterday. But that's the point. The point is simply this. There is no fact pleaded as a fact that this motion of no confidence has lapsed. Number one. So then the court would have to go to the second aspect. Is it moot for some other reason? Because there's no fact like a child leaving or an eviction that's happened or anything like that. Then the court looks at, well, has there been a lapsing through time? And I want to show you the absurdity of the argument on the common cause facts in the law. If were the court to take that view, that there's a lapse of time, and I like to go through the chronology on this, and it's absurd on every level to come to the conclusion we would submit that the case is moot on this lapsing of time aspect without a fact such as the child was left the school, or that I'll come to a case, or Archbishop Tutu's, late Archbishop Tutu's birthday has come and gone with respect to the Dalai Lama, and I'll come to that. The facts are, on the 11th of February 2020, my client brings the motion. For various procedural reasons, Lukaleni AJ only heard the challenge to the question of the open-close vote in February 2021. The case then proceeds to the SEA. It's decided, it was argued I think in November 2021, but decided in December 2021. At that point, although there's been this lapse of time of almost 2 years, there's no suggestion that the matter was moot by any of the parties, the Speaker, any of the other parties to the case, the President, or the SCA. So in December 2021, we know it's not moot. No suggestion of mootness. Then we move to, very shortly thereafter, the ATM.
Well, mootness wasn't considered as the bottom line with regard to the SCA.
But if it had been, it would have been absurd, we suggested. That's why they didn't consider it. Then in January 2022, the case is alive. And the ATM go back to the Speaker and they say, look what the SCA found a month or two ago. Please, we want our vote. Closed. Again, it's a rejection. The ATM brings an urgent application. Comes before IDJ. There's no suggestion of mootness. So when is this trigger? When is this line that happened? When is the child leaving the school? When is the time period lapsing? We come before IDJ, she strikes it from the roll, and go to the JP, the then JP and the DJPs, now acting JP's officers, you will find an incredible attempt by the ATM to get the matter back on the roll. Eventually in August, the then JP, the JP, sets the matter down for the 15th of January this year. We write it, then we bring out other case. The Speaker says, please don't have it on the 15th of January for various reasons, but no problem with that. Please have it on today. When did it become moot? And there is no answer. So we would submit as a matter of principle. This matter cannot be regarded as moot, and it would be absurd to do so. Let me turn to the
Why don't the cases say that motions of this nature are inherently urgent?
I have been bleating on about that for 10 years.
No, but the cases say that.
I've argued it, and Davis J said it, and then it went to Moseneke Beach. It's insane.
The cases say that because if they're not dealt with urgently, they become academic. I mean, the test for urgency is that if it's not heard, if the matter's not dealt with urgently, then it can't be effectively dealt with at all.
Well, let me say this, Justice Binsmore. We agree with you. So in other words, that's the very point that Davis J was making all those years ago. That if you bring a motion of no confidence, like in England, it should be the first order of the business of the Parliament before the next sitting. So other matters take second reading starts. We, I can say this, I mean, me personally, I've recognized it for all of the clients that I've been sitting, and who has been blocking it? The Speaker. And the Speaker gets away with having the motion not dealt with for the very reasons you articulate, Justice Binsmore. And in this case, it's classically one would be grossly unfair to let the Speaker get away with such conduct. They've blocked. And let me say this, in Rukuleni AJ's judgment, I don't know if the court's had an opportunity to read it. The first point that the Speaker took is this court doesn't have jurisdiction. Why? Because they said in terms of section 164E, it is only the Constitutional Court that could hear such a matter. Well, Justice Lafranchi, that's what we have been dealing with for 10 years. And I say we, being me personally. Every step of the way, we've been blocked. We eventually get to argue our point on ATM 1 here. The court raises Miramoto a point of mootness, and what happens? The Speaker jumps onto it.
Well, it's either moot or it isn't moot.
It's not moot. And even if it is moot, I'm going to come to now my dominant argument on this aspect. Let's assume the court finds it moot. I will turn to the Buthelezi decision, where I stood up in court and I speak about personal experience, and if I had a hard time yesterday, it was an easy time compared to what I had on that day when it came to the question of mootness. I'll turn to the facts of that case. Many years ago in Jordan, the Constitutional Court heard an application for confirmation of a striking down of an act concerning sex workers. The first judgment in the little bundle that I'm getting to today. And the High Court had a challenge in respect to 4 grounds about the dignity of the sex workers, quality, and various other aspects. And the Constitution and the High Court only upheld one of the aspects of why the sex worker provision was unconstitutional, but left the other 3 because, and this is the important point, it found, High Court, that it didn't need to deal with the other 3 because the one succeeded. It goes on confirmation to the Constitutional Court, and the Chief Justice, he
Chaskelson
Nkubo J.
No, Chaskelson CJ presided there.
Yes, in Nkubo J.
Okay.
Yes, Justice Binford. You should remember it because there's a later case in which you were junior counsel, which at this point was argued, which I'll give you the reference.
Well, I wasn't junior counsel in 2002, so I can't be junior counsel in a later case.
The later case was two. I'll give you the reference now because I know there's a comeback to this point. Two, and I was also in the case. I was also junior counsel. And you were, with respect,
I
Justice.
took Silk in 2000.
2008.
Sorry,
If you were senior counsel, then you were senior counsel. Sorry, you were the junior to Rogers SC. You were the SC with Rogers.
I wasn't the junior to Rogers SC. We were arguing separate parts of the case. We're talking about the Heath case.
Yes.
And in the Heath case, the judgment refers to me as Mr. Rogers.
That I didn't remember.
Mr. Rogers was actually my substitute in that case because I wasn't available. And then I became available and I was called in to argue just one aspect of the case.
What I do remember, my memory is that, sorry, off the topic, but you gave a presentation to the applicant, not in the case, person, as counsel when you went down, and it was one of the more impressive presentations I've heard, and that became a case.
Flattery would get you. Let's get on with it.
But the point is this. So in Jordan, the Constitutional Court suggested that when a High Court is faced with various challenges which may go further, it would be preferable for the High Court to deal with all the challenges. And were the court to dismiss this ATM 1 on mootness, we would submit that it would be appropriate that the court opines on the merits of ATM 1 for that reason. I'll come to the Buthelezi decision in a second.
So what do you want to take us to in Jordan?
Paragraph 2021, which is on page 4. The simple proposition is that in the second sentence in paragraph 21, and I know the court will come back and say, well, this was the constitutionality of provisions not an issue, but the same principles apply, like in the Heath case. I'll give the court the references. It wasn't Heath, in fact, it was a Erasmus Commission.
That's right.
Where the constitutionality of a provision is challenged on a number of grounds, I've made that point, and the court upholds one, it is desirable that it should also express its opinion on the other challenges. And the reason for that in our case is were the court to uphold the mootness point, or mere motive was not be raised, it would be desirable for the court to express its opinion on the merits of ATM 1. That's our first proposition. And let me just add two cases to the Jordan proposition. I understand, Justice President, you may put to me that this applies in the context of confirmation proceedings. And we not, in this court, were the court to, let's call it, uphold our challenge, it would not be subject to a confirmation proceeding. So there is a distinguishing feature in respect of this proposition. But I want to give the court two other judgments where the High Court order, in respect of both, where they struck down the conduct of the organ of state, wasn't subject to confirmation proceeding. Nevertheless, the High Court found it appropriate to follow the Jordan principle and dealt with, let's call it, the other challenges. The first is this, the Erasmus Commission point, City of Cape Town versus Premier, 2008, volume 6, essay 345 at paragraph 167. And the other case is a judgment of the SCA, more recent. It's Minister of Justice 2016, ZASC, that's the neutral citation, ZASCA 196, SCA 2 December 20. Sorry. It's the neutral citation. It's 2016 ZASCA 196, SCA 2 December 2016, and particularly at paragraph 38. But I want to come to the next case in our bundle to demonstrate why, were the court to take the first line, which is moot, but you'll deal with the other, that would be a wrong approach. Because in PECO, in Kambenda J, which is the next little case in our bundle, question arose as to the mootness of the case. And what the case was about was a group of people who were living on the side of a dolomite geo site, if I can call it that. And the local authority was very concerned that this group of people would fall into the hole and there'd be mass deaths. So what the municipality did is it relied on the Disaster Management Act and evicted the people. And they were moved to somewhere else, and now they came to court and said our eviction was not compliant with PI, and there was the debate about how PI related to the Disaster Management Act. The case went along its way to the Constitutional Court, and by the time it got to the Constitutional Court, the people had long been moved off the site. So the actual eviction the horse had bolted, in the words of the court yesterday. And in paragraph 31, 32, they talk about the IEC versus Langburg municipality, old judgment dealing with the questions on discretion to decide issues on appeal, even if no longer in live controversies. Discretion must be exercised in the interest of justice, etc. Paragraph 32, the key paragraph of the proposition that I'm now advancing. It is beyond question that the interdictory relief sought will have no consequence, as they have, the people, the group, have already been removed from Bucksfontein. So were we to ask for, that's why I hesitate about my substitution point. Although the removal has taken place, this case still presents a live controversy, this is the point, regarding the lawfulness of the eviction. And we would submit likewise, this case, Period 2 ATM 1, presents a live controversy regarding the lawfulness of the Speaker's decision. Generally, unlawful conduct is unequal to the rule of law and to the development of that society. Needless to say, and this is important, the ATM replaced here for the applicants have an interest in the adjudication of the constitutional issue at stake. And in our case, the constitutional issue at stake is, did the Speaker act lawfully or not in her closed secret government?
But I don't know if you're going to get to the judgment of Mr. Justice Wallace in the SCA in the someone referred to yesterday. Yes.
It's the Stratford Court.
There a distinction was drawn between the approach to mootness by appellate courts and first instance courts. And I mean, the Constitutional Court, in saying what it said in paragraph 32, in the various judgments in Pecker, is speaking from the perspective of mootness seen through the eyes of the appellate court. In other words, there was an issue here which was worthy of decision in the general interest. I mean, this is why surely she's speaking about generally unlawful conduct inimical to the rule of law and the development of a society based on dignity, equality and freedom. I mean, the court considered it important, notwithstanding the fact that the factual basis for the dispute was no longer alive, that a determination be made on this issue, on this important issue.
What can be more important than...
No, but appellate courts are allowed to do that according to Wallace J.A.'s judgment. First instance courts aren't.
No.
If the matters become moot, well, according to the Wallace J.A. judgment, a first instance court will say, well, I'm not dealing... in fact, it doesn't say I'm not dealing with it. It says I can't deal with it.
The court knows my submission that that nobody is dead in this case. The motion of no conference is a lie. The motion of no conference is a lie. And my client's entitled to know, as a matter of fact and law, whether the Speaker, and I'm going to come to this, exercised her power lawfully. And everything that you've heard, we submit, and I understand that our friend does not talk to how she exercised. I'm going to emphasize that word how in between ATM 1 and 2, because that's the key. And my client is entitled to know, as a matter of right, whether the Speaker exercised her discretion in respect of ATM's request lawfully, how she exercised it. I'll come to that, but I will come to that. I want to turn to the next case, because the court knows my submission. The next case is a similar type principle to that of Pecker. What happened here was the World Cup in 2010 was coming up, and Bishop Tutu was turning 80, Archbishop Tutu, and he had a birthday celebration coming up. And he wanted to combine a piece that's called an initiative for the World Cup with his birthday. So he had a birthday celebration. And what he did as part of his birthday celebration was a few months before, let's say this was in October, I can't remember, maybe June or May, June, he invited the Dalai Lama to come to his peace birthday. And what happened was, by the nature of things, the Dalai Lama had to apply for a visa from Home Affairs, which he did from, I'm not sure whether India or one of those countries. I think there was some complication about that. But ultimately, Home Affairs declined not to grant him a visa, but declined to even consider his application for a visa. And by the time the party came and finished, the World Cup happened, the Dalai Lama couldn't attend the party. And the previous Minister of Home Affairs, Mangosuthu Buthelezi, who was a friend of the Dalai Lama, claimed that he would invite the Dalai Lama to another peace event. So he came to court to complain that Home Affairs had obstructed the Dalai Lama coming to Archbishop's birthday, and that obstruction was unlawful. So he brings a case. I represent the applicant, and I stood up in this court. And if I had a hard time yesterday, it was a picnic yesterday compared to the hard time I had there, about one issue, mootness. And the two judges said, but Mr. Katz, the party has come and gone. There's no live controversy. That's absurd.
Dutch status, was it?
He was the, I think I was described as somebody who was such a pupil, was sitting at the back of the hall, and he described the debate between I and Judge Davis as a fiery Shabbat dinner between the father and the son. I'm not sure who was the father and who was the son. But the point where Justice Bartman actually wrote the judgment was Davis was declaring. And then we took it on appeal. And we came before the SCA, and Nugent J.A. in paragraph 4 says the party had come and gone, the application was dismissed because on the grounds that there was no live controversy. That was rightly not pressed in argument before us. And the only reason it's been pressed by our learned friends today is from a cue from the bench. There's nothing in the heads of argument, there's nothing on the pleadings. And then what Justice Nugent says about the fact that it wasn't rightly pressed by Home Affairs, whether the authorities had acted lawfully was and remains a live issue. Whether the Speaker acted lawfully was and remains a live issue. They would not be called upon to reconsider their conduct if they acted unlawfully goes only to whether a decision on that question would have practical effect. In view of the appellant's intentions, it cannot be said that it would not. But what is
the import of that last sentence?
Mr. Former Minister Buthelezi.
No, but in view of the appellant's intentions, what were the appellant's intentions?
Yes, the former Minister Buthelezi was going to invite the Dalai Lama to come to another peace party post World Cup.
Okay, so this was still a live issue then?
Exactly in our case. My client has, this is the point, in February 20, this is the timeline that I gave you the report earlier, he started this quest in 2020, February. It's now 3 years later. He still wants a motion no conflict, and he still wants to be secret. That's his intention. Just like former Minister Buthelezi, his intention to invite the Dalai Lama to a party. He wants, and he's entitled to, 1, a motion no conflict. That's the court to settle, constitutional court. 2, he wants the Speaker to make a decision that it's secret ballot. He's entitled to that decision lawfully made. That he's entitled to. He's not entitled to a secret ballot, that I accept. But what he is entitled to is that when the Speaker makes a decision, she must do so lawfully. And he's come to this court, he's begged court after court after court to make a determination on that issue. And at this hour, to say it's mooted because of a non-reason. There's no reason that it's mooted. So we would submit on those cases, and that Jordan principle we would suggest sharply that the matter is not moot, and even if it is moot, then the court should opine on it on the basis of the 3 cases that I've given the court. I'll turn then to ATM 1 itself, to the extent that the court is inclined to consider the question of threat 2 of the motion. There were a number of submissions made by the Speaker, not the ANC, but the Speaker. But none of those submissions dealt with.
Are you correct? ATM 2 now?
ATM 1. Not one of them dealt what we would submit for a particular paragraph, well, dealt with particularly paragraph 28 on page 15. It hasn't been dealt with in the answering affidavit, nor in heads of argument, nor in oral argument. And there's a good reason why it hasn't been dealt with. Words have meaning. And Justice Burns-Ward, we agree entirely with your Lordship's sentiments when you say you're a procedural stickler. We would add, we're a stickler for words. And when the speaker uses words, they have a meaning. And one can't, oh, it's a little bit clumsy. It doesn't work that way. And these are her words. In this letter, I will not repeat the contents of the earlier letter, except to state openness remains the default position. The speaker cannot run from that and say clumsy, I didn't mean what I said. It's not permitted. And we've given the court the reference to the Constitutional Court where they say, that's response by a learned friend. Clumsy, it isn't what I meant, is not acceptable. When it comes to interpreting legislation, when it comes to interpreting regulations, policies, or words of the executive, when a human being speaks and uses words in a language, they must be taken to mean what they say, and they must be taken to say what they mean. And she meant what she said, which is openness remains the default position. And this court, the Speaker, ANC, EFF, and us cannot run from those words of her. So we would submit on any level. Our learned friend hasn't dealt with it, understanding he's a brilliant advocate, because he can't deal with it. That's what brilliant advocates do. They avoid topics that they cannot deal with, and he has not dealt with it.
But the Speaker says that her decision was made on the 4th, and those words that you say it's got all that meaning was ex post facto on the 5th, I think.
No, this is a different case. This is the ATM 1 point. This is the 16th of February, the 9th of March. So what she says on the 9th of March is this is what I meant on the 16th of February. And one can say anything about those words, but what one cannot say is that she didn't get the ATM Supreme Court of Appeal decision wrong. One cannot say that. She got it wrong. Now let me just turn to the ATM decision on an aspect which is crucial to this court's determination or opinion on whether those words mean anything. In the ATM decision yesterday, my learned friend from the EFF touched upon a particular aspect which we say should dominate this court. I was there, and what I argued was that on the basis of the paragraph that you have, this court has debated back and forth proposition, since she failed to appreciate, and the word how is italic. And we've heard a lot from Mr. Butler, a lot from Mr. Ngwatobi about that's how democracy works. It's irrelevant. The real issue is how did she approach it? And you
she approached it on the basis that there was an onus on you.
Excuse me.
The Speaker approached it on the basis of implying an onus on the ATM.
In that case.
Yes, that's Mr. Butler said.
Yes,
and
correct.
right. This case is about whether the Speaker was fundamentally misdirected because she implied an onus.
Absolutely.
When there wasn't one.
Absolutely.
Yeah. That's what this case is about.
Absolutely, and that's what this case is about today, for your lordships. Openness remains the default position. Now, if the court says to me, well, the default position means no onus, then I'm going to live with that. But I would submit that isn't how the law works. Where a decision maker says to a liquor license applicant or a driver's license applicant or an ATM applicant for an applicant requested for a closed vote, there is a default position. That means onus. So it's beyond a reasonable doubt in the criminal context, balance of convenience in a civil case. It means default, and it goes further. She does go further. I just used those 5 words. And that since my last visit, there's been no change in the substantive legal and constitutional framework to compel deviation. If that is not an onus, well then I'm not here. That is onus. That's the language of onus. I come to her and I say to her, I wish to have a closed vote. And she says, the default position is not what you want, and you haven't shown a deviation from the default position. That is onus, onus, onus. Cannot get away from that. And Mr. Butler can't get away from it. So we would say that's our case on ATM 1. I want to turn to ATM 2, but before I do so, I'd like to make two gentle points. They're gentle, but they're sharp. And when I say sharp, they pick up on all the concerns that Justice Tularia has been raising with all the parties for the last day. They're gentle and sharp at the same time. And that is the elephant in this room, state capture. And Commissioner Zondo deals with it in his report as to on the question of this party discipline issue. And what he says is contained in the affidavit, or sorry, it's contained in the annexes to the affidavit. And perhaps I should just
Well, I don't think I'm the first person to have seen it in that light. I seem to recall reading words to that effect in one of the judgments I read in preparation for this case.
Well, let me answer it like this. To extent, this is the point, sorry, this is the exact point. To the extent...
I think it was the UDM judgment.
No, I don't.
Yeah, just thinking loud, counsel, it seems to me that there is an attempt to judicialize Parliament.
Not the intent. Well, I'm intending just
legalize.
There we go. Legalize. When the National Assembly acts, just like just like the court, just like the President, it must act lawfully. Not judicialize, legalize.
I'm saying decisions that are taken through parliamentary processes are political processes.
Let's accept that for the purpose of the debate.
Yes, but it seems to me that, you know, I'm just thinking like there is what other people refer to as lawfare, all right, to bring some kind of judicialization of the political environment. I think the structure of our constitution, so far as I understand, is that a political terrain has got its own laws and its own games. And it seems to me that it may be dangerous to put judges in a position where they have to second guess, you know, political considerations that comes in.
They must never do that. Never do
Yes.
that. They must never, ever, no judge in this country has the right to ever second guess political considerations. But every judge has the duty and obligation under the Constitution to scrutinize the lawfulness of conduct by other bodies such as the Executive and the National Assembly. And that's what we ask this court to do. We're not asking the court to scrutinize whether the decision was right, wrong, or why the political decisions were made. What we are asking the court to do is to scrutinize whether how the decision by the Speaker was made was lawful. That's all. It's one question, and it's a law question, not a political question. Yes, there are suggestions on the papers that the Speaker is a member of one party which is there to protect the President. I'm not asking for that. I accept that. That would be a stretch. That's the way the structure of the National Assembly has been made. If we look at Johannesburg City Council last week, there's a coalition government, and this case is important. More importantly so, because of the possibility, and I'm not a predictor of politics, when the national government, the national, let's put it, political environment becomes coalition politics, then we will see why this case is so important, because then we have, well, we've seen it in the Johannesburg City Council, I don't understand, we know. We happen to see the lens of 25 years or maybe 30 years of a situation where it happens to be that the Speaker and the President are from the same party, number one, in the national legislative environment, and from the majority party, unlike in a coalition government. But that situation changes radically as soon as you move towards, as we've seen in the local government sphere, coalition politics in this country. So, Justice Delore, you're absolutely right. That this court has no judge, Constitutional Court, Supreme Court of Appeal, High Court, no judge has the power to scrutinize political decisions which have political outcomes. But every judge, from the Constitutional Court down, has an obligation, just a power, an obligation, when it comes before the court, to scrutinize the lawfulness of conduct by the Executive and by the... and let me just say, the proposition that you put to me, Justice Delore, was the very proposition, I made this point yesterday, that the Speaker put to the Constitutional Court in the EFF case. The Chief Justice rejected the proposition. And returned, and there was an order in the case, we've given it to the court in the second bundle, which found that the National Assembly had failed to comply with its, let's call it its oversight role, because of how it went about scrutinizing the Parliament. And that's what we submit to. And when one has regard to the words, again the words have meaning, of the Speaker in this case, and one I think Justice Lafranchi, you were talking to me earlier, you were putting to me a question on, let me just get it right. On the 5th, the 4th and the 5th.
Yeah. But you were arguing in terms of ATM 1 and not ATM 2.
No, I put the words ATM 1. We cannot get away from the, she cannot get away from the words openness, deviation. That's onus. And if that isn't onus, then there is no such thing as onus in language. That is onus. But if one turns to what Justice Lafranchi, the 18th...
Before you go there, what with regard to the two decisions, the one in terms of ATM 1?
It's one decision.
You say it's one decision,
It's
not two decisions.
That's one decision. Yes. And one reason which are conglomerate.
Okay.
In ATM 1 or ATM 2?
Both. Well, let me just come to the question. On
page ATM 1 now.
Yes, ATM 1. You asked me about ATM 1.
Yes,
and I'll answer it.
But there's a review of two decisions.
It's one decision about one request, which is to have an open... Let me turn to ATM 2 on this question. I think you were debating it. I have a note about something here, which I just have to get there. And it goes like this. On the 4th, she gives written reasons. On the 5th, there is a programming committee meeting in the National Assembly. And there has been the criticism from the Speaker of my client's approach of review, hoping for the code name. That's the criticism. Now, that criticism is a criticism that should point back at the Speaker. And let me say why. On the 5th, we say, on page 15, 16 of ATM 2, we turned up at a meeting and this is what she said. We weren't asking her for anything. There's no cycle of review. It's the Speaker. And again, I come to her words, not our words. She says on page 16, she just says it. The first issue is the date, and the next issue is the manual roll call. Let me just say, as far as the ANC are concerned, we agreed to a manual roll call, yes. It's a far cry from agreeing to an open ballot. And that's why I say, friend for the ANC made the point.
Sorry, how does a manual, after the manual vote operate to define the voter identity and the manner in which they voted would be...
I understood, I'm sorry, just to clarify, my understanding is that the DAMP explained what they were saying, what they meant.
What do you say a manual vote is?
UDM explains it all right, for the UDM case says it was. What I say.
Manual vote?
Yes.
What is a manual vote?
On page 16 of our bundle, paragraph 67, there are very different methods of how it can happen. But what in the third sentence, but read together, sub-rules 1 and 3 of Rule 104 empower the Speaker to predetermine a manual voting system that may not permit a recall or disclosure of the names and votes. This is indiscriminate manual secret ballot procedure. Indiscriminate because it's not limited to the election of the President. It's very simple. A manual vote can or can't be secret or open.
But that's not what the DAMP asked.
Well, the DA might be for openness or
No,
I don't.
I'm talking about in the meeting, on the papers before us, in the meeting,
Yes.
when the DA moved for this kind of vote, it explained how, and I think I'm going to took us to that place.
Well,
Ms. Bahube explained what process they had in mind.
dodging the question. It was 5 minutes. 5 minutes enough.
It's not a question. I've answered. If there's any question,
No, it's 5 minutes enough to wrap up.
It should be enough. It should be enough. It depends on the questions that come from. But I think this is not an unimportant
We've
issue.
got your hint.
Excuse me?
We've got your hint about questions.
Yes. No, I welcome questions. There's nothing more disconcerting than for any council sitting on, yeah. sitting and looking at a stone bench. I think, and I welcome. But here, our learned friend again, we make the point. Sorry, I have to say, I mean, I listened yesterday this morning to our learned. They were brilliant. But that's as far as it was. We've now taken to what the cases that they around actually say, and it's exactly the opposite of what they submitted. And let me just say one thing about the ANC submissions this morning, which are just wrong, plain wrong on every level. The gravamen was that there are certain MPs who wish the president to be removed, and there are others who don't, and that's a political process. And he assumes, the underlying assumption, which is absolutely wrong, is that those MPs who voted to uphold the report wish to have the president removed. Absolutely not. What they voted for is to hold the president accountable in respect of a valid binding report by 3 eminent jurists. That's what they voted for. Not to remove him. That will become at the end once he's had an opportunity to deal with the issue. So our learned friend for the ANC is absolutely wrong to make that submission about what some MPs want or don't want. It's just not true on the facts. So I turn to our learned friend for the Speaker's submission on corruption watch, which Your Lordship, Justice Burns Ward, I think it's a very interesting question, the reverse of Curd and Odecroft. And this is the law as stated by the Constitutional Court, which our learned friend usefully pointed to. It's on page 21 of the small bundle of today. And on this judgment, we submit that prayer 3 must follow were you to be with the ATM on prayer 2. In Seal versus Van Rooyen, which is referred to in paragraph 32, there is a quote by the Constitutional Court quotes from Seal versus Van Rooyen next to the letter F on 459 of the reported decision. It says, the reliance by counsel on the decision in Odecroft is misplaced. As appears from the itemized part of the judgment, that's the have legal effect for as long as the initial act is not set outside by slightly above it next to this E. As appears from the itemized part which was quoted, the analysis was accepted by this court, that's the SCA, as being limited to a consideration of the validity of the second act performed consequence upon a first invalid act, pending a decision whether the first act is to be set aside or not. The court did not in Odecroft suggest analysis was relevant to the latter decision. Then the important paragraphs. The Supreme Court then concluded that it is clear from Odecroft that if the first act is set aside, and the important words, a second act, and these are the key words from my advice, that depends on its validity on the first act must be invalid as the legal foundation for its performance was non-existent.
Well, that was clarified in the discussion I had with Mr. Button yesterday.
Yeah, absolutely. So here, if the Speaker did not exercise her power validly, then the vote itself falls because it was dependent upon the validity of her exercise of power. That's the simple proposition. So it cannot be suggested that the vote in Parliament is moved when otherwise not available for attack under prayer 3. And just to lead into our learned friend from the ANC's submission this morning about the question of whether the panel report is dead or not, there seemed to be an equivocation that it was dead, that was his first submission, and if it is dead, this is not a resurrection issue. That is dead, but if a court of competent jurisdiction sets aside the vote, then the report becomes alive again. That can't be. It's either dead or it's not dead. And he did quite fairly to him. He said it's a tough question in the debate with Justice Clinton, whether it's dead and it's alive or not. And that question. And I'm not suggesting that it's not a question without some difficulty. But what we would submit very clearly on the authorities is that were the court to come to the conclusion that Prayer 2 is available to us for present purposes, Prayer 3 would certainly follow on the basis of what I've just read to the court from corruption. Can I just take an instruction on, well, might just take a word of that. That's fine. So I understand from having the last submission. There was a suggestion in the debate that there is and my understanding of the debate, I don't want to get it wrong, that the Speaker may appropriately presume that the MPs would vote in accordance with their oath of office, as opposed to having speculative views, a feeling, as Justice Tulare put it, as to how MPs would vote. That kind of debate, sort of feeling debate. And I want to answer it like this. What is the evidence before, not this court, but what is the evidence that was before the Speaker? And that is what this court will consider. Not speculation, not feelings. And the evidence was clear that there is, and these are the words of the Constitutional Court, and this is the standard that has to be met, a real possibility that MPs from whichever party, Justice Tulare, for whatever reason, may not, because of the prevailing circumstances, whatever they may be, vote in accordance with, I use the word conscience because that's the word in the judgments, but in accordance with their state oath. And if this court takes the view that the Speaker was right to say that there's no real possibility, she loses anyway, because that isn't how she articulated her reasons. And the last judgment in the bundle that I've given the court is something that piqued the court's attention yesterday when it debated with our learned friend for the EFF. And we asked the Minister of Environmental Affairs versus Hambili. That became Batterstar in the Constitutional Court, where the Scuts JA spoke to the question of reasons. And that starts on page 15 above the paragraph 39. I know this is the context of Paja, but even though we're not in Paja, the same principles apply, we can submit. And the question of those Australian cases dealing with the question of whether or not a conclusion that the situation is not that toxified, that a closed vote is called for. Her reasons fail on the level of this judgment by the SCA. She did her reasons that she states in a letter on the 4th, if one ignores what she says on the 5th, in a letter of February 16, ignore what one says on the 9th of March, and what she says in her affidavit fails. There's no reasoning process. She just makes a conclusion.
It's odd that you advance these arguments in the context of what actually happened, because the reasons were provided in the letter. There was no response from ATM to say, well, hang on, these aren't reasons. Substantiate your conclusions in this letter. On the contrary, they said, thank you very much. We accept these reasons. We accept that you're acting in good faith. But please think about it again.
And then what did she do?
No, but I mean, you're attacking the reasons of the good faith.
No. As we look back, I'm not talking about bad faith. I accept the bad faith.
No, you're talking about reasons. I appreciate that. But your client didn't raise any issue about the inadequacy of the reasons at the time. I mean, it considered the reasons. It appeared to accept them, but say, please reconsider.
Oh no, with respect, it never accepted the reasons, this open quote reasons.
Didn't accept, It asked her to reconsider the conclusion.
That's it, not her reasons. That's exactly the point of this matter. It asked her to reconsider not her reasons. Just all the questions that I've been put to make our case. She didn't. If one stands back to that.
The argument now is that one must look at the reasons insufficient, and it's not the real reasons. That's not what your client says. Your client says, well, how did she come to a conclusion? And the conclusion is unlawful.
Well, let me ask Justice Franklin.
Your case, as we understand it, is not about the inadequacy of the speaker's reasons in the letter. Your case is the letter's going to be read together with what she said later. If you read what she said later, it's quite clear that she actually went against the ATM judgment. That's your case.
Yes, absolutely. Yeah. But as one of the sort of, let's call it add-ons, when one makes that submission, the submission that you just put to me, which is the correct submission.
I don't make submissions anymore.
No, the proposition that you put to me is to our submission. And that is our submission, I accept that. Part and parcel of our submission is how is the court going to analyze, and importantly, how she came to her decision. And how the court does that is look at her reasoning process. And you don't have that. That's the problem. Other than no deviation because there are no extraordinary circumstances. That's the process. That's how she did it. And she doesn't tell you, well, this party that disciplined its members with expulsion immediately is only 10 members. We had the debate yesterday. You had the debate with my little friend. It doesn't really affect the vote for these reasons. It doesn't do that. There's no analysis. There's no analysis at all of how she came to the conclusion, other than these glib conclusions. South Africa's robust, particularly so, and therefore it's not. She's accepted it's toxic, but not that toxifying.
I think we've exhausted this stuff.
Yeah. Anything else, Mr. Katz?
Thank you for being so patient with me, and I have been given an instruction that it's time for me to sit down.
This is one issue I think that bothers me. I'm not too sure what my two brothers think about it, but the issue of grade 2 and grade 3.
In ATM 2?
Yeah.
Yes.
A lot of things said about it. I wonder if perhaps we can't have sort of I don't want to hits, but just to clarify that score for us better, because there was a lot of to and fro, a lot of debate and argument about it, and all of the heads are rather thin on that score. As if you compare 2 granted. What about grade 3?
That's a word of mine.
Yeah.
We don't expect you to deal with it now.
No, I'm just asking. Is may I make the following suggestion? That on the assumption that the court is with us on grade 2, the question arises whether 3 automatically follows. Yeah. And we make the proposal that we will file, I'm not going to say short, but I'm going to say written submissions by next Wednesday. What's today? Today's Tuesday. Sorry, by Friday.
This week.
Maybe make it Monday. Just be easier.
Monday next week. The week's start will be fine with us.
Next Monday is fine.
All the parties can get a week and a half to file brief submissions just on those issues. It's a limited trip.
So the one issue that
yes. Mr.
Well, that's perfectly in order. My experience is it works best if they file first and we answer, because otherwise we talk past each other. Yes. So perhaps if they file within a week, we could file within a week thereafter, if that's not going to delay the bench.
No.
Thank you.
So we'll file on Monday.
You can make the arrangements
yes, of course.
between yourselves.
So we from us will file on the 21st.
Try to get something to us, I'd say, certainly within 2 weeks.
So we will file on Monday the 21st.
Yes. Mr. Button was
they can do as they so choose.
Well, you can arrange a timetable.
I can't speak to
Mr.
the
How are you feeling about that?
Yes, we will file at the same time as the speaker.
Okay.
But I'm rising on a different point if this conversation is over.
Oh.
Yeah.
Yes.
I have no objection as long as I get the last word. And I'm not sure what the EFF's attitude, if they have the right to file anything on that bread.
No, because they don't ask any relief.
I'm not commenting.
No, it's Mr. Nkoli.
Yes, it's to correct a factual point which I have no doubt was not deliberately made. Justice Binswad asked, what is a manual vote? Firstly, it is answered in paragraph 40, but if that remains confusing, it's answered clearer at page 425, where the Speaker issues a media statement recording the discussions of the National Assembly Planning Committee on the 5th of December 2022. In the third paragraph, she says, the meeting further resolved that the voting method on the report will be by means of an open ballot and a roll call. Thank you.
You should show your hands, you've got nothing to add on that.
I will file a note on next Monday.
To all the council, thank you so much for argument. We will reserve judgment in and we will deliver judgment so when you're ready. Please will adjourn.
This wants to come back. He also wants to come back. Thank you. Because he wants to know what the law is. Well,